All right. Today, our topic is intellectual property law. So this is RA 8293 as amended. Our discussion is again based on the Supreme Court issued syllabus for the 2023 bar examination. Okay. And in that particular syllabus, the topic will start with intellectual property rights. Okay. And these are intellectual property rights. This is actually a term that is defined under the law, RA 8293, to include one, copyright and other related rights. Okay. Now, at this juncture, let us emphasize what are these related rights. We will be discussing in the semester what is copyright. Okay, and these are actually the economic rights. Okay, but aside from the economic rights, there are also moral rights. Okay, so these are the rights to be attributed if you are the author of the work. You ought to be recognized or acknowledged whenever someone will use your work. Okay, while that may not be economic in nature, okay, because that particular acknowledgement may not be compensated, but that is a moral right. And there are occasions wherein moral rights are asked in the examination, and some examinees would question, saying that it's not part of the syllabus, but um, intellectual property rights is, of course, part of the syllabus. And if you will look at the definition of what are these intellectual property rights, clearly it includes these related rights. So in our latter discussion, we will discuss what are these moral rights. So let's go back to intellectual property rights. So it consists of copyright and other related rights. It also consists of trademark and service marks, also geographic indications, also industrial designs. Fifth is patent. And then sixth is layout designs of integrated circuits. So that's IC. And seven, protection of undisclosed information. Okay, so these seven consist of intellectual property rights, but mainly the topics in the bar exam would focus on copyright, trademark, and patent. Okay, now very important that we know the difference between copyright, trademark, and patent. Okay, so in many cases, the Supreme Court emphasized the difference of these three. Okay, trademark or let's begin with copyright because we include we we mentioned this ahead. Okay, so copyright is confined to literary or artistic domain, and these are protected from the moment of creation. Okay, while trademarks, these are visible signs that would distinguish goods or services. Okay, and patents, this are patent on the other hand is any technical solution. So this is the invention part that is new. It involves inventive step and industrially applicable. Okay, so these are what we call copyright, trademark, and patents. And in so many cases, particularly in the case of Eli.co, an open cited case, the Supreme Court said that this intellectual property rights cannot be interchanged. Okay, meaning if, let's say, for example, A authored a book, okay, and this book is within the literary or artistic domain. Hence, this is a proper subject of copyright. Let's say B is engaged in business and he has this logo which he used to distinguish his goods from other goods. Let's say B is in the business of selling shoes and his logo is known by the customer such that if they will see this logo, they will know that this is the shoes produced and sold by B. So, because this is a visible sign that distinguishes the shoes of B from the shoes of C, D, etc., then this is the proper subject matter of trademark. And let's say, for example, D. So D made an invention. Okay, let's say he was able to come up with a drug for COVID. Okay, and this is new. It involves inventive step and industry applicable. Hence, this is covered by patent. Supposing, okay, supposing that D is selling the same drug, okay, and C filed a case against D for patent infringement. However, C has no patent, meaning he did not apply for patent registration. What C was claiming was that he was able to secure copyright and trademark for the drug. Can C make B liable for patent infringement? The answer is no. Okay, and the reason for that is that this intellectual property rights, patent, trademark, and copyrights are different intellectual property creations and they cannot be interchanged. Okay, so I think if you will be asked in the examination and the facts are similar, let's say, for example, the proper subject matter is trademark. So, but instead of trademark, the petitioner or the one that filed a case against another has copyright or patent. So, in that particular case, the case should be dismissed because again, intellectual property rights cannot be interchanged. They are different intellectual property creations and they cannot be interchanged. So very important, this particular phrase when you formulate your answer. Now, in 2017, okay, a case was decided by the court and the case is 1 versus 1. Okay, so this is actually a case again involving siblings. Okay, so Fernando versus Roberto. Okay, but Roberto at the time died and he was succeeded or substituted by his son. Okay, now the case arose because one of the siblings has a business, laundromatic. Okay, so this is of course from the name we can deduce that this is a parang laundry service. Okay, now this laundromatic is therefore not copyright, not trademark, and not an invention. So laundromatic was used as a trademark. name. Okay? Now, this trade name was actually used by the sibling, one of the sibling, and unknown to him, okay? Unknown to him, yung kapatid niya, nagpapa-franchise na pala, okay? Of Laundromatic. So, the case was filed, and the trial court in that case said no one among the siblings can use Laundromatic because the court said when he searched the internet, this um, the name. Okay? By the way, ang pangalan niya, ang trade name niya, actually, yung trade name is actually Labandera ko. Okay? Now, this is the name of the business, okay? Yung um, washing of clothes business, okay? And the court said wala, right? Wala. Between the siblings can use the name La Bandera Ko because this is a title of a song, okay? Hence, it belonged to the composer of the song. And the Supreme Court said such ruling of the trial court is erroneous because, again, if this is the title of a song, therefore this is copyright. But ang pinag-aagawan ng sibling is a trade name. So, we discussed about copyright, trademark, and patent. Okay? They are different intellectual property creations and they cannot be interchanged. Okay, so it's possible that in the problem, instead of asking trademark, what is asked is a trade name. Okay, so you will also apply that particular principle that they cannot be interchanged. Now, at this juncture, I think it's best that we discuss trademark versus trade name. Okay, so trademark, like what we said, is a visible sign, and this visible sign is to distinguish either goods or services, and it includes the container, the mark container. Okay, I think we are all familiar with goods, right? Some of us are quite fond of buying a specific brand of shampoo, of detergent, of anything, of watch, of clothes, okay? And those are examples of trademark because it distinguishes the kind of product that we use. Now, if we are availing of such service, like for example, a bank, or let's say a telecommunication company, so those are services, then the sign that distinguishes their services are also a trademark. Actually, to be precise about it, it's called service mark, and this is called trademark. The generic term actually for trademark and service mark is mark, okay? But we will use trademark as a generic term that may cover both trademark or service mark. Now, trade name, however, is not the same as trademark. It is a name used to distinguish an enterprise. So in short, ito yung pangalan ng tindahan o nung negosyo in order to differentiate this enterprise from similar enterprises. Okay, so example, for banks, BPI or BDO, And this is to distinguish that particular bank from other banks like Metro Bank, Union Bank, etc. Okay, so the name of the business versus the name or the visible sign to distinguish the goods. Okay, so I think I hope that's clear. Now, if this is the question, now we have this particular case law to use as a basis of our answer. That hindi rin natin pwedeng pagsamahin or i-treat the same ang trade name at copyright. Okay? So that's the importance of knowing the difference between trademark, copyright, and patent, and trade name. I think this was already asked in the examination, and of course, the likelihood that this will be asked again, because this is a basic concept, is quite high. All right, now with that, we go now to patents. Okay, now in the intellectual property law, okay, the sequence would be patents, trademarks, and copyright. So this is also the sequence of our discussion. Patent is actually from section 21 to section 120 of the Intellectual Property Code. Based on the syllabus, it starts with patentable inventions. Okay? Now, what are patentable inventions? I think the best way to discuss this is to first clarify what is an invention. An invention is any technical solution. Okay? Now, saan siya solution? To a problem. So there is a problem and the solution is a technical one. Therefore, this is an invention. Okay? Now, let's have example. You have a problem and the solution is merely an advice to follow. Yeah, like for example, magpakabait tayo dyan, or magdasal lang tayo, or let's say for example, matulog tayo ng maaga. Indeed, those are solutions, but those are not technical solutions. So let's say for example, the problem is insomnia, hindi makatulog. Okay? And the solution was, manood ka lang ng isang napaka-boring na movie. Of course, that is a solution, right? But that is not a technical solution. A technical solution, for example, is a medicine. Okay? A medicine that is formulated in order to cure insomnia. Then that is an invention. Now, the question is this medicine patentable? The answer should be based on whether the medicine contains all the elements of patentability. And what are the elements of patentability? Must be new or novel. Number two, it must involve inventive step. And number three, it must be industrially applicable. Okay, now, so these are patentable inventions. Okay, now what are non-patentable inventions? Okay, so again, we are talking of an invention, okay, but these are not patentable. Okay, so kahit ma-invento mo to, hindi ka makakakuha ng patent para dito. Okay, now what are non-patentable inventions? I think this may be classified into two. Number one, those inventions that lack the elements of patentability. Sabihin, hindi siya new, wala siyang inventive step, IS, at wala din siyang industrial application. any of these three elements will deny the patentability of such invention. Number 2 category would be if they fall under section 22 or the non-patentable inventions. Okay? So, kahit bago ito, kahit it involves inventive step, kahit ito ay industrially applicable, then if they fall under section 22, then they are not patentable. Now, this patentable, ano bang ibig sabihin niya? Okay? Ibig sabihin niyan, the invention may be patented. At ano ang ibig sabihin ng patented? If the invention obtained patent, okay, or patent, depende sa paano mo gustong sabihin, okay, that particular invention is what they call protected. What do you mean protected? Protected because the patent owner may prevent others from making, using, offering for sale, selling, or importing the product or process that is subject matter of patent. Okay? So let's say, for example, A was able to invent X and X was patented. Okay? Now, if X is patented by A, let's say, for example, B would like to manufacture X, then A can file patent infringement case against B. If C, for example, would want to use it without the consent of A, then A, as a general rule, may file a case against C. If, let's say, for example, D is offering for sale X, then A can file a case against D for patent infringement, and so on and so forth. Okay, so very important that you recognize these 5 acts that others or third parties cannot do without the consent of A. So let's say, for example, if B would want to sell, if B would want to manufacture, if E would want to sell, if F would want to import this X, what should they do first? They should obtain the consent of A so that B can manufacture X, C can use X, D can offer to sell X, E can sell X, or F import X. Okay? In short, anong ginawa ng Estado? If A was given a patent, A was given a monopoly. Okay? At alam naman natin yung function ng monopoly. Okay? It prevents competition. At ano mangyayari if there's no competition? Pag walang competition, then A can dictate the price. Okay? It is for this reason that intellectual property bears a social function. Okay? Kaya hindi basta-basta ibinibigay ng Estado yung patent na yan. For the state to grant patent, dapat susunod sa batas yung nag-a-apply ng patent. And among the rules that the patent, that the inventor must follow is to ensure first that the invention has all these elements of patentability. Okay? So, we are actually discussing intellectual property, right? So these are property rights. Yeah, I think that this is a very important concept na kailangan mai-familiarize natin, right? Because we are talking about property. If this is a property, then why are we discussing this under commercial law and not under civil code? Okay? Diba? Bakit nasa commercial law subject ito at hindi nasa civil law subject? Okay? I'm sure your civil law professor or reviewer discuss intangible properties, and that includes property, right? But there is a special law on IP. Okay, and this is RA 8293, which is covered under commercial law. Okay, now let's go back to the elements of patentability. So, what are the elements again? Number one, it must be new. At ano mang ibig sabihin ng new? It must be novel. Dapat bago siya. Okay? At anong ibig sabihin? Ano ang technical definition of what is novelty? According to the law, novelty is when the invention does not form prior art. Okay? In short, hindi siya prior art. And what is prior art? If you will look at your law, okay, 8293, this is actually section 24. Okay? Now, in section 24, there are two paragraphs. Paragraph 1, it is prior right. It is prior art when it already exists and available to the public anywhere, not only in the Philippines but in the world. Okay? So kapag available na, let's say for example, A said that he was able to invent this particular X, and the examiner, let's say for example, the patent examiner, okay, knows that X already exists in, let's say, China, or in QC, or in Bangladesh, or anywhere else in the world. Should the patent examiner grant the application of A? Answer no. Why not? If that is the question. Because it is no longer novel. Why? Because it is no longer it forms prior art. Okay, bakit siya prior art? Because the facts show that it is already available in China, Bangladesh, or Quezon City. Now, section 24, like what we said earlier, hindi lang isang paragraph. May second paragraph na yan, and this I think is more important. Prior art may also consist of the whole content of an application for patent. Okay? Utility model or industrial design. So, kapag meron na palang nag-apply nauna kay A, then that is already prior art. Okay? So, to illustrate, let's say, for example, A was able to invent X, or so he claims. So, A filed his patent application, let's say, April 24, 2023. Okay? Now, when A filed his application for patent on April 24, 2023, the patent examiner said, you know what, A, B Another person also claims that he invented X. And B, filed his application, let's say, for example, April 15, 2023. So, nauna yung application ni B. Supposing the question is, if you are the patent examiner, will you grant the application of A? Siyempre, ang sagot doon is no, I will not grant the application of A. And what is the reason? Because A's application for patent registration of X should be denied because X is no longer new. Why? Because X is already prior art, because it is the content of a prior application. Okay? Now, I'm sure dahil sa ganitong discussion, maalala na natin yung rule na first to file rule. Right? The first to file rule. So, it means that the person that filed or who filed the application first will have the right to a patent. Of course, this is subject to several exceptions, but as a general rule, we follow first to file rule as enunciated in the intellectual property law. So if the question is, let's say, for example, it was shown in the fact that it was actually the first invented X. Nagkataon lang that B was able to file his application earlier, assuming that there is no bad faith, that the invention was made independently from one another. In other words, A was able to come up with X on his own. B was able to come up with X on his own. Nagkataon lang that B was able to file the application first. Then, because of the first to file rule, the patent should be given to B. Okay? So that is the element of novelty or new. The second element is that the invention must involve an inventive step. Okay? Now, ano naman tong inventive step na to? An invention involves an inventive step if, having regard to a prior art, it is not obvious to a person skilled in the art. Okay? So in short, para mabigyan ka ng patent, dapat yung na-invento mo is something that is not obvious to a person skilled in the art. Let's say, for example, A. He claims that he invented X. Okay? Now, when the patent examiner was examining the application of A, the patent examiner asked B, what can you say about X? Is it something that is obvious to you or not? If, let's say, for example, B says the invention of A is not obvious to me, at hindi ko agad yan may isip. Kailangan mag-research muna ako. Will we say that this invention is patentable because it is not obvious to B? Well, the answer to that is we need to determine first, who is B? Okay? Is B a person skilled in the art? Meaning, si B ba ay marunong dito sa kung anumang X na ito? If it's drug or medicine, si B ba ay someone knowledgeable in drug or medicine? If X is, let's say, for example, appliance, an appliance, or a gadget is the person is skilled in the art in the manufacture of appliances or gadgets. Then if B is such a person and B says, no, it's not obvious to me, then the invention may be granted. Okay? But on the other hand, if we will say, and that particular statement is credible, be saying, kadali-dali naman yan, anyone in the industry would know that, right? Then the invention lacks inventive step. Okay? Now, there is also this important discussion insofar as drugs or medicine is concerned. Okay? Because section 26.2 okay, of the intellectual property law says that in cases of drug, let's say, ito yung pinapapatent. There is no inventive step when the invention results from mere discovery of a new form or property, okay, of a known substance. Okay. Now, to give an example, let's say, for example, A is a drug manufacturing firm. They hold a patent on X, which is a medicine, and the patent is about to expire. At dahil mag-expire yan, okay, so mawawalan si A ng monopoly over X. So what A did was to say that, let's say, this X is in a capsule form. Okay, ang ginawa ni X, invento nga tayo ng liquid form. Okay? Now, from capsule to liquid, and now A was now applying for a patent for X in its liquid form. Should the patent application be granted? The answer to that is no, because it is no longer patentable because it lacks inventive step. Okay, and your answer should be focused, should contain this. The mere discovery of a new form, okay, will not make the invention patentable for lack of inventive step. Same with property. Let's say, for example, A owns a patent over drug X, and this X is, let's say, for example, a cure for the liver. Okay? Now, yung mga gumagamit ng medicine na ito, nakita nila pumuputi ata sila. So, nagiging fair yung complexion, and because of that, A applied for a new patent for X, not as a liver medicine, but as a whitening supplement. Should A be given patent for X? Answer, no more. Okay, because it lacks inventive step, because it's a mere discovery of a new property. Right? Na-discover lang nila yung medicine na ito, ang property nito ay for liver. Nakita nila ay may bagong property pala ito. Do not be mistaken to say that drugs are not patentable. It is patentable as long as it contains all the elements of patentability. Now, Section 26.2, however, says that meron siyang inventive step if the process involves an improvement. Okay, so let's say, for example, A owns a patent for X, okay, and through constant research and development, the company was able to come up with X 1. Okay? And this is an improvement of X. And this improvement, okay, employs at least one new reactant. So, to simplify, may kakaibang reactant doon sa improved medicine na yan, then this is capable of being given another patent as long as this improvement employs a new reactant. And again, yung elements of patentability, it must be new, involves an inventive step, and industrially applicable. Right? And speaking of the third element of industrial or industrially applicable, okay, it just means that the invention can be produced, and used in any industry. In other words, may benefit sa sangkatauhan. Right? Then this is industrially applicable. Now, next topic would be non-patentable inventions. So, non-patentable inventions. Okay? Now, this is section 22, right? This section is composed of 6 paragraphs, which are all important because there are so many questions in the bar examination that were based on this section, section 22. So section 22, paragraph 1 is about discoveries, scientific theories, okay, mathematical methods, okay, um, or and section 22 also say something about drugs and medicine, or almost the same discussion dun sa inventive step. Okay, now supposing that the question is, let's say for example, A discovered X, no? Please take note of the word use, discovered, and not invented. So X is an element that is new. Sa sobrang bago niya, pwede siyang ilagay dun sa periodic table of element. Kung posible yun. Right? So nakadiscover na panibagong element, wala pang nakakadiscover. And the question now is, can A secure a patent over X? The answer is no, because this is a mere discovery. Same with scientific theory or mathematical method. Now, number 2, under section 22, would be schemes, rules, methods of performing mental acts, playing games, doing business, and programs for computers. Okay, so and to illustrate this, let's say, for example, A was able to invent a game. Okay, can A secure a patent over this game? Okay, a game that is more exciting than basketball or kung ano man yung favorite yung sport. Right? Is A entitled to patent this game? Answer no, by express provision of the law. Right? Playing games, doing business, not patentable. Third is method of treatment. Again, method of treatment of human or animal body, including diagnosis. But Section 22.3 does not apply to any product or composition for use for this method. Okay? So clearly, yung produkto or composition to treat or diagnose, patentable yan. Right? So this is the reason why medicines are patentable, but not the method for treatment. So let's say, for example, Dr. A is a respected cardiologist, so he has this system that he prescribes to his patient. Let's say, for example lang po, hindi ito totoo. Let's say, ang prescription ni Dr. A ay kumain ka ng mga ganitong mga gulay at pagkain. At tumakbo ka ng 30 minutes every day, assuming wala pang gumagawa ng gano'n, assuming that is a new prescription, okay? So let's say, for example, sabi ni Dr. A, dapat yung pagkain mo laging may cinnamon. Hindi cinnamon, cinnamon lagi. Okay? Now, supposing that no other doctors are prescribing this and that prescription has proven to be effective. And Dr. B is now prescribing the same to his patients. Dr. A learned about this act of Dr. B, so Dr. A is now suing Dr. B for patent infringement. Question, is Dr. B liable for patent infringement? The answer is no, because that is not patentable. Assuming that the question is, Dr. A went to the Intellectual Property Office to apply for patent registration for this prescription, that the patient should eat this kind of food at this amount and should walk 30 minutes per day at this particular time of the day. Should the Intellectual Property Office grant patent to this? Answer, no, because this is a mere method for treatment. Same with diagnosis. That is not patentable. Okay? Not patentable. However, let's say, for example, Dr. A was able to come up with a drug that he prescribes to his patient. And this drug was made subject of a patent application of Dr. A. Should the Intellectual Property Office grant patent to A, assuming that this medicine contains all the elements of patentability? The answer is yes, right? Because this is not a mere method of treatment. It is a product, right? A product for use in the method of treatment. Number 4 would be plant or animal breeds. So, naka-invento ka ng bagong breed ng aso, ng kabayo, ng pusa. Okay? Can you secure a patent for this animal breed? No, ang sagot, by express provision of Section 22.4. Okay? However, okay, if what you invented is a microorganism. Okay, yung mga microorganisms, okay? Now, this can be subject of patent. Okay? Now, number 5, aesthetic creations. These are proper subject of copyright, right? May be covered by copyright, but not patent. And finally, number 6, if the invention is contrary to public order or morality, then this is not patentable. Alright, so let's say ang invention mo ay drug, and this drug um, parang pang weapon of mass destruction. Or kung drug na ito ay papatay ng mabilis sa napakaraming tao basta ilagay lang sa kung saan man. At by airborne, etc., etc. This may be not patentable because it is contrary to public order. Okay? So, rape drug, for example, or yung mga drug na ginagamit sa mga kung ano-anong illegal na activity. Pag ininom mo to, tatapang ka so that you will be brave enough to commit crimes. Then I think these are examples of an invention that is contrary to morality and also public order. Hence, you cannot obtain patent. Okay? Now, next topic under the syllabus is ownership. Like what we mentioned earlier, patent is a property. And because it is property, therefore it is subject of ownership. Question, who owns the patent or who has the right to a patent? Now, to answer this, you need to be careful with the facts given to you. Okay? The general rule is that the inventor has the right to a patent. Let's say, for example, A was able to invent X. Okay? Then A is the inventor, and as a general rule, A has a right to a patent. Siya ang mag-apply sa patent at and because of that, he will be entitled to the patent. Okay? Now, the law says that the inventor or his heirs or assigns. So in short, because property nga ito ni A, pwede niya itong ipamana sa kanyang mga heirs. Pwede rin namang i-assign by virtue of a deed of assignment. Okay? So, that is the general rule. We mentioned about the first to file rule. Right, in our given example, A was able to invent X, and he filed an application on April 24, 2023. Supposing that in order for A to come up with X, he was assisted by B, and they were successful. Okay? So A and B work together to come up with X. A filed his application on April 24. B filed his application on April 15. So nauna siya kay A. The question now is, who owns the patent? If your answer is B, then that is not a correct answer. Okay? Because for the first to file rule, you need to look at the facts and you need to see that A and B made the invention separately and independently. Independent from each other. Why? Because in this given example, it was shown that A and B collaborated because it was shown that B assisted A. Therefore, okay, ang rule dito ay joint ownership. Subject, of course, baka may ibang klaseng relationship si A tsaka si B, which we will discuss later. But if, let's say, for example, they partnered on X, okay? So, the rule is joint ownership. But if the problem will state that A invented X on his own laboratory, B was able to invent the same for some reason, the same X, okay, independent from A, then we apply the first to file rule. Okay, now there is also this right of priority. Under section 31. Ano naman tong right of priority? This is when a patent application was filed in a foreign country. And this foreign country grants the same privilege to Filipinos. Okay? Now, ano essentially ang application nito? Ang sinasabi ng Section 31, if the patent application was filed in this foreign country that grants the same privilege to Filipino, then the date of filing in that foreign country is deemed the date of filing in the Philippines. Okay? Now, again, A and B separately and independently from each other, both came up with X, the same invention. A filed this application April 24, 2023. B filed this application April 15, 2023. So under the first to file rule, B should be given patent, right? But supposing in the given example, A filed in the United States and the problem says that the United States grants the same privilege to Filipinos. And the date of filing in the US is, let's say, for example, April 14, 2023. So ahead siya dito sa April 15. Under the right of priority, then A is entitled to patent, not B. Okay? So, right of priority versus first to file rule. Now, di ba, we mentioned earlier about yung relationship ni A tsaka ni B. Now, supposing B was an employee of B. B was an employee of A, or A commissioned B. So, dalawang pwedeng mangyari, right? So, this is the application of Section 30, right? Inventions created pursuant to unemployment or commission. Now, very important to distinguish employment from commission. And dali naman yan, right? Yung labor law na topic, yung kalaman natin, the employee-employer relationship. If there is such employee-employer relationship, then that is employment. If no employee-employer relationship, then that is merely commission. Supposing that the question says, A commissioned B to work on an invention X, and B was successful. So, question, who owns the patent? As a general rule, the person who commissions shall own the patent unless there is an agreement to the contrary. Okay, so pwedeng in the agreement, let's say for example, A commissioned B to work on X, and they agreed that in case of success, B shall have ownership over the patent. then B has the right of patent. But if there's no such agreement, then A shall own the patent. But if, let's say, the problem states that A employed, so merong employee-employee relationship, A employed B, and B was able to come up with X. Who owns the patent? If this is the case, remember the problem. A employed B, and B was able to come up with X. There was no mention that A employed B for the purpose of coming up with X. Supposing hinar niya si B as his counsel, pero may scientific mind pala si B. So while in the office at walang ginagawa, using company time and resources, B, the lawyer, was able to come up with X. Then who owns the patent? The answer, it is B who owns the patent, because the determination as to who owns the patent will determine whether such invention is part of the regular duties of the employee. Okay, so in the given example, B was the lawyer, right? He was not the scientist, he was not the lab technician, he was not the chief investor, right? Kung may mga ganong posisyon, right? Ang trabaho niya ay para maging abogado. Then definitely the inventive activity is not part of his regular duty. Therefore, kahit pag ginagamit ni B, yung company time and resources, it is B who owns the patent, except of course whenever there is an agreement to the contrary. However, if A will employ B at ang purpose talaga ni B, why he was employed, was to invent para sa kumpanya or para kay A, then it is A who owns the patent. Okay, unless of course there is an agreement to the contrary. Okay, that's the rule whenever an invention was made pursuant to a commission or employment. All right. Now we go now to the next topic, which is the grounds for cancellation. Okay. Now, in this particular case, it presupposes that patent was already granted. Okay. And because patent was granted, someone would want to have this canceled. Why niya gugustuhin ma-cancel? Kasi nga, di ba, kanina, ang illustration, if you need, or if you want to make, to use, to offer for sale, to sell, or to import the patented product or process, you need to obtain consent. Eh kung pinahihirapan ka, or masyadong mahal yung consent ni inventor, then you might as well cancel the patent. Okay? Now, now before this pala, we need to discuss. So, paano ba makakakuha ng patent? Okay? Ang short answer dito is for the inventor to be given patent, he must apply for registration. In one case, okay, the court said no patent, no protection. Okay, so let's say, for example, the problem states that A was able to invent X. So because he was able to invent X, he was so happy about it, but he did not apply. Patent registration. Now, while using X, okay, B saw X, and B is knowledgeable about how to come up with his own X. And because of that, B was able to manufacture and sell X And because of that, nakikita ni A na mas yumayaman si B. And A filed a case against B for patent infringement. If this is the question to you, what will be your answer? If the question is, should you hold B liable for patent infringement? Then the answer is no, because no patent, no protection. It was not shown in the problem that A filed an application, nor was given a patent over X. And because of that, then X can be exploited by anyone. And it is too late now for A to file a patent application because hindi na new ang invention. Okay? So very important that this concept, no patent, no protection. Now, assuming that application was made and it was granted, what is now the remedy of B? Okay? Now, supposing D is an interested person. As an interested person, B may file a petition to cancel the patent. But it must be based on a specific ground. This is actually section 61. Okay? Now the grounds are, number one, the invention is not new, nor it is patentable. In other words, B may challenge the patentability of X in a petition for the cancellation of patent. Number two, there was insufficient disclosure. Okay, ano ba itong insufficient disclosure? On the patent was not disclosed in a manner sufficiently clear to be carried out by a person skilled in the art. So there was insufficient disclosure because, di ba, we mentioned about application for patent registration. This application, meron niyang procedure. And part of the procedure is to disclose the invention. If the disclosure is not sufficient or was not sufficient in order for a person skilled in the art to carry out such invention, then it is pwedeng ipa-cancel. And third is the patent is contrary to public order or morality. Then these are the three grounds for the cancellation of the patent. Okay? Now, Section 61 also says that pwede naman yung partial cancellation. Right? Pwedeng hindi buo yung libong patent yung ma-cancel on the part, then that's possible. Now, the syllabus also contains the topic remedy. Right? Remedy of the true and actual inventor. Okay, this is section 67 and section 68. If you will look at section 67, okay, you will see there that if a person referred to in section 29 is declared by a final court order as having right to a patent, such person may, within 3 months after the decision has become final, may prosecute the application as his own. Second, file a new patent application. Third, request the application to be refused and for to seek cancellation. So, babalik tayo dun sa section 61. Now, sino ba itong section 29 na to? Who is this person referred to in section 29? Di ba ito yung first to file rule? So, supposing that ganito yung nangyari. A invented X, B separate from A invented X. A filed this application April 24, 2023. B filed this application April 15, 2023, and therefore B is the first filer. And as a first filer, di ba, under the first to file rule, B is entitled to a patent. But for some reason, the patent was given to A. Okay? Now, ang sabi ng section 67, if this person is declared by final court order. In other words, nagkasuhan sila sa husgado. And the court, the court issued a final court order declaring B as the person entitled to the patent. What are the remedies of B? So dapat may final court order muna. Ha? Walang final court order, don't apply section 67. Okay? What are the remedies of B in this case? Ito yung apat na to. Prosecute the application as his own, file a new patent application, request the refusal of the application or to seek the cancellation. Now, what about this true and actual inventor? Ang situation naman natin dito is, let's say, for example, A, assistant niya si B. So they came up with X. So assistant lang talaga si B. Pero without A's knowing it, B applied for patent. Okay? And the patent was granted to B. So this A is the true and actual inventor. What is the remedy of A in such a case? So just like in section 67, there must be a final court order. In short, dapat pumunta sa husgado si A. I-challenge niya at sabihin niya that I am the true and actual inventor. Okay? And if the court issued this final court order, okay, then the court shall order the substitution as patentee, or at the option of the true and actual inventor, cancel the patent and award actual damages. Okay? So, dapat yung court order na to, meron na rin dapat na substitution of the patentee. Okay? Right. Now, so what are the rights? Next topic. Rights conferred by patent. Okay? So this is section 71. Okay? And section 71 says that the patent shall confer on its owner the following exclusive rights. Ba, natandaan nyo sabing monopoly kanina, right? Kasi exclusive right ang binibigay ng patent. Okay? Where the subject matter of patent is a product, patent will give the exclusive rights to manufacture, using, making, using, offering for sale, selling, or importing the product. Okay? So, exclusive right to manufacture, to make, to use, to offer for sale, to sell, and to import. At kasama dyan yung to prevent or to restrain others such that kapag may gumagawa ng ganitong mga acts, anong pwedeng gawin ni patent owner? Kasuhan ng patent infringement. Okay? Now, if the patent is over a process, Section 71 says, ganun din, to restrain others from making, using, offering for sale, selling, or importing the process as well as the product that is the output of the process. So mas malawak ang karapatan if the invention or the patent is on a process than a product. Okay? Section 71 also says that the patent owners also has the right to assign, okay, transfer by succession of the patent and to conclude licensing contracts. Okay? So part of our discussion would be yung procedure, the formalities required in transferring or assigning patent rights, and also part of the syllabus for the 2023 bar examination is the licensing of patent. Okay? Now, next topic is limitations. Okay? Limitations of patent rights. Okay. Ano ba itong limitation of patent rights? Di ba, we mentioned earlier that, let's say, for example, A was given patent on X, okay? And because of that patent granted to A may prevent or restrain others from making, using, offering for sale, or selling, or importing X. Okay? Now, ano itong limitation? In other words, if let's say, for example, B would want to make, use, offer for sale, sell, or import X, okay? Now, he may do so if, without the consent of A, if B's action would fall under the limitation of patents. Okay? So, in short, ito yung mga defenses. Defenses that B may avail of when A would sue him or her for patent infringement. Okay? Now, limitations would include, number one, when the product has been put on the market. Okay? So in short, binibenta na ni A yung X, B bought it, and B is now using it. Definitely, hindi mo pwedeng idemanda. Right? Hindi naman pwede idemanda ni A yung si B dahil B is using it because A put the product or the X on the market. Okay? Now, with respect to drug or medicine, okay? With respect to drug or medicine, Section 72.1 says that if the medicine has been introduced in the Philippines or anywhere else in the world, Okay? That medicine may be imported. Okay? May be imported um, um, by third party. The purpose of this law is, of course, to in the effort of the government to bring down the prices of medicine. Okay? So, let's say, for example, yung patent owner ng medicine na yun ayaw mag-import kasi nga the dami supply, napakamahal. So, other parties may import the said medicine because it's already introduced in the country, right? And this is for the purpose of ensuring that the said medicine is sold at a cheaper price. Second limitation is when the act is done privately. Privately and non-commercial scale. Okay? Provided that it does not significantly prejudice the economic interest of the owner of the patent. So let's say, for example, A owns a patent on X, and B, let's say this is a drug for COVID, and let's say, for example, P is a skilled in the art of formulating medicine. So because X was disclosed, B can manufacture the medicine on his own as long as he will use it privately at hindi naman niya binibenta, right? Then A cannot sue B. Well, pwede namang i-demanda, but B has a legitimate defense. The defense is that his act or her act is done privately and only on a non-commercial scale, and such would not prejudice the economic interest of A. Now, third is when the act consists merely of experiments. Experiments for the purpose of obtaining permission. Let's say, for example, A owns a patent on X. So, for a period of 20 years from filing date, A has exclusive right to X. Diba? Now, kapag nag-expire na yung patent na yan, ano mangyayari? Anyone can now sell X. Pero, if we are talking about drugs, di ba hindi ka naman porke makagawa ng drugs, ibibenta mo na. There are a lot of permits, there are a lot of licenses, right? That the manufacturer should obtain, lalo na sa bayan natin, right? Napakahigpit ng ating mga regulators tungkol dyan. So, kung mag-aantay pa sila ng 20 years para mag-experiment at makakuha ng mga permit, di tatagal pa rin. So, in short, even during the lifetime of the patent, other manufacturers may experiment on and actually try to obtain the necessary permission so that day one of the expiration, they are ready to sell. This is BOLAR provision. Right? Now, number 4, when the act consists merely of preparation for individual cases. Okay? This is also a limitation. So parang yung kaninang example natin dito, may patented drug, okay? And someone can manufacture the drug for his or herself lang. Then this is a there is a this is a limitation. Number 5 is when the infringing activity is used in any ship, vessel, aircraft, okay, or land vehicles, okay, of other country. In other words, yung ship na to, vessel na to, taga-ibang bansa ito, and they entered Philippine territory, okay, temporarily or accidentally, and the infringing activity is only confined in the vessel or in the ship or in the vehicle, and this is used only for the exclusive needs of the vehicle, then this is not actionable in our country, in our jurisdiction. Okay? Now, other limitations would include prior user. Okay? Ano ba itong prior user na to? Prior user is when someone has been using the invention or the subject matter patent in good faith. Okay? Therefore, this person is not liable for patent infringement. So, let's say, for example, A was able to obtain patent for X. And let's say the patent was granted April 15, 2023. Okay? So after the filing the application, after the rigorous examination, finally the patent was granted on April 15, 2023. Okay? Now, A is now enjoying the hard work for X. So naibibenta niya, and anyone who wants to sell X would need a license from A. But one day he discovered that B is using and also selling a medicine or a product similar to X. Okay? Now, A filed a case against B to cease and desist from making or using or selling the X. Huh? If you are the counsel of B, what is your defense? The defense is B is a prior user and he is in good faith. So dapat may good faith. Halimbawa, if B was able to use or sell X kasi nga nag-spy lang pala siya kay X, kay A. Habang ginagawa ni A yung X na to, nag-spy si B, and because of that, nalaman niya paano ba gumawa nito. So, P will not be excused for using or selling X, right? Because he is not or she is not in good faith. Okay? Now, another limitation is when it is the government use of government. Okay? Now, if this is the case, then walang magagawa si si patent owner. But of course, yung sinabi kong walang magagawa, it presupposes that the government, okay, also follow the rule. Why? Bakit kailangan si gobyerno mismo ay mag-follow the rule? Because, di ba, IP is a property. At anong sabi ng ating Constitution? No person shall be deprived of life, liberty, or property without due process. So in short, even if it's the government that will use the patent, there must be sufficient ground. At ano yung importance ng ground na to? Kasi pag walang valid ground, then this is a violation of the substantive right to due process of the patent. So dapat may valid ground. Ano yung mga valid ground dito? Number one, it is for the public interest. Okay, in particular, national security, nutrition, health, development, okay, as determined by appropriate agency. Okay, so national security, health, lalo na in the midst of COVID. Now, let's say, for example, A owns a patent over X, and this X is a potent cure for COVID. Okay? Ang problema, si A ayaw niyang magbigay ng license kasi gusto niyang siya lang ang kumita dito. What can be done by the government in this particular case? I-avail ito. Right? Use of the government. Okay? Because in this particular limitation, the government agency or even a third person authorized by the government may exploit the invention even without the agreement of the patent owner. Why? Because there is this need of the public. There's this public interest, health issue, public health issue. Okay? And number two, when there is a judicial or administrative body that has determined that the manner of exploitation is anti-competitive. Okay? Di ba, sir, sabi mo kanina, monopoly. Di ba pag monopoly, may anti-competitive talaga yan. Bakit ngayon sinasabi natin that whenever there is a judicial or administrative determination that the manner of exploitation is anti-competitive, pwedeng gamitin ito. Pwedeng the use of the government. Ang explanation natin dito, I think it's best to illustrate this. Let's have example, let's say A was able to invent X, and X is, let's say, a battery, a new battery for all gadgets, particularly for mobile phone. Okay? And this battery is such innovative na ang laking katitiran ng lahat ng gagamit ito. So, A was given patent for this invention. So A entered into an exclusive contract with B, who is a seller of mobile phone. But there are other mobile phone sellers, C, D, E, F, G, H, I, J, K, etc. So, anong nangyari dito? Exclusive lang kay B yung produkto ni A. So, in short, yung patent, yung exclusivity ni A supposedly for battery alone, na-extend niya yung kanyang monopoly doon sa mobile phone business. Okay? Such that B, C, D, E, F, G, H, I, J, wala nang bumibili ng mga produkto nila kasi nga because of the exclusivity given by A to B. So in this particular case, this is anti-competitive. If there is a judicial, again, please, before you apply to, there must be showing in the facts that there was a judicial or administrative findings that the manner of exploitation has become anti-competitive. Then you apply this particular use of the government. Okay? Now, patent infringement. Okay? What is this patent infringement? Madalas na natin sinabi ito kanina. Patent infringement occurs when there is a person who is making, using, offering for sale, or selling, or importing the patented product or process without the consent of the patent owner. Okay, because of this, the patent owner may file a patent infringement case against the patent infringer. Okay, so infringement, pangungopya. Okay, so wala kang pahintulot na kopyahin yung patent na yun. Now, there are two tests in patent infringement. Number one, the literal infringement. Okay, so literal infringement is, diba, we mentioned earlier that when someone will apply patent, there is this disclosure. Okay, so yung infringer, kinapi lahat ng nakita niya sa disclosure. Then this is patent infringement, literal infringement. Second is the doctrine of equivalence. Okay, doctrine of equivalence is when the disclosure was not copied verbatimly, but the product is the same as X. Let's say, for example, this is X sold by A. B has his version or her version of X, and this is Y, and this Y has the same function, the same method, and the same result of X, then this is the doctrine of equivalence. This was asked in the examination and in the bar examination, and the question was based on a particular case, Smith-Kline versus Court of Appeals. The Supreme Court said in that case, if the sameness, yung pagkakapares lang is the result, and there was no showing that the function and the method to obtain the same result is not present, then there is no application of the doctrine of equivalence. So in short, if this will be asked in the examination, okay, at ang pinakitang sameness lang ay result at hindi pinakita yung sameness sa method at sa function, then do not apply the doctrine of equivalence. Okay? Now, if there is a person that infringed the patent, ano yung mga liabilities niya? So, ang liabilities niya is yung tinatawag na threefold liabilities. Threefold. Number one, civil, criminal, and administrative. Right? The law provides civil, criminal, and administrative liabilities to the infringer. Okay, so insofar as civil liability is concerned, usually mga damages yan. At criminal is pwedeng makulong. Okay, makukulong. Right? But the law says that before an infringer be criminally liable, there must be a repetition first. So yung unang kaso, wala pang criminal case. Pero pag umulit, then magkakaroon na ng criminal liability. And for administrative, this is filed in the Bureau of Legal Affairs. So there are administrative remedies also available against the infringer. Please take note of the prescriptive period. Okay? For damages, okay? For damages, the action must be filed within 4 years from the commission of the offense. Okay? Now, we go now to the next topic, which is licensing. Okay? What is this licensing? Okay? Ito yung tinatawag na technology transfer arrangement. So this is defined in the law, right, as a contract involving transfer of technology. So kaya nga siya nililisensya. Okay, let's say, for example, A owns a patent over this drug or over X, okay? And A may enter into a contract with B. If this is done voluntarily or conventional, okay, then this is what we call voluntary licensing. Okay? Later, merong licensing na hindi voluntary, and that is what they call compulsory licensing. But let's focus first on voluntary licensing. Okay? This is covered by Section 85. Okay? So, Section 85 of the law of Republic Act 8293. Now, because the contract is voluntary, then we apply yung principles of contract dito. Okay? We apply the principle of contract that parties are free to stipulate, etc., etc. However, okay? However, in Section 87, it contains what we call prohibited clauses, meaning the law says that whenever A and B would conclude voluntary licensing, they should not include in the license any of these prohibited clauses. Okay? In order to manage time, right, I invite you to take a peek at Section 87, and those are the prohibited clauses. Curiously, there are actually bar exams. One of the bar examination asked, cite at least 3 prohibited clauses, cite at least 3 mandatory clauses. So I don't think that will be asked ever again, right? But I think it's important that you have an idea of what are these prohibited clauses. One of the an example is, let's say, for example, A and B concluded a voluntary licensing agreement, and part of the license contract is for B to obtain the raw materials from a specific supplier. Then this is a prohibited clause. Kasi nga, another monopoly na naman ang mangyayari dito. So that is actually the purpose of Section 87. Okay, it avoids or to contain restrictions, okay, para sa competition. Now, Section 88 is about mandatory clauses. So dapat naman ito ang mga nakalagay. So Section 88, like what I said earlier, okay? Like what I said earlier, there was already a bar exam that says cite at least 3 prohibited clauses, cite at least 3 mandatory clauses. So please, again, take note of these 2 sections. Meron bang exception dito? Yes, there is an exception. And the exception is found in Section 91. If there are exceptional cases, and these exceptional cases are illustrated in Section 91. That's, for example, high technology content, increase in foreign exchange earnings, employment generation, etc., etc. The parties may obtain an exception from the Intellectual Property Office, particularly the Bureau of Documentation, Information Technology Transfer Bureau. so that they can obtain an exception, so that they may include certain prohibited clauses, or they may exclude certain mandatory clauses. Sir, pwede ba ito na, di ba, violation ito sa doctrine of yung principle of independence ng kontrata? But of course, we know the answer to that, right? Parties are free to stipulate as long as their stipulation are not contrary to law. Right? So this is a particular example of a law that prohibits stipulation in a contract. But the parties are allowed to seek exemption if section the exceptional circumstances are present as mentioned in section 91. Question now is, what is the effect? Okay, what is the effect? Okay, what is the effect if a voluntary licensing contract fails to comply with section 87 and 88? Okay, the result is that it is unenforceable. Okay, it is unenforceable. Is there a remedy? Yes, there is a remedy. You need to register the contract with the Bureau of Documentation. Okay, but supposing, the question is, supposing that there is this voluntary licensing contract that complies with section 87 and 88, kailangan pa ba na iparegister ito? Answer, di naman kailangan. Okay? Only when it violates section 87 and 88. Without the approval and registration with the Bureau of Documentation, the voluntary licensing contract is deemed unenforceable. Right? Now we go now to compulsory. Compulsory licensing. Okay? So just like yung usapan natin kanina dun sa use of the government, okay? Compulsory licensing is a license wherein the patent owner was compelled to grant. Okay, no choice to compel to grant. Again, to fully appreciate what is yung meat nito, i-refer ulit natin siya sa Constitution. Right? No person shall be deprived of life, liberty, or property without due process. Right? So, yung due process na umiiral dito is, number one, dapat papasok siya sa grounds. There are valid grounds para mag-grant ng compulsory license. And these grounds are found in section 93. So, we talk about national emergency or other extreme urgency. Number two, where public interest, okay, again, security, nutrition, health. Number three, judicial or administrative determination that it is anti-competitive. So, di ba parang napag-usapan na natin ito kanina, yung use of the government. But in this particular case, may karagdagan. In case of public non-commercial use. In other words, kapaki-pakinabang naman yung patent, pero hindi nagiging available sa public without satisfactory reason. Okay? And number 5, the patented invention is not being worked in the Philippines on a commercial scale. Okay, so mataas ang demand pero hindi pinoproduce sa Pilipinas on a commercial scale, although it's capable of being worked without satisfactory reason. However, the same law provides that if ini-import naman, okay, if it's being imported, then it shall constitute working or using the patent. Okay, so I hope clear yan. Okay, so paano ba maka-obtain ng compulsory license? So ganito yung situation. A owns a patent of X, pero merong available grounds dito. So anong gagawin ni B para siya mag-granta ng compulsory license? Mag-file ng petition si B sa Intellectual Property Office, particularly sa Bureau of Legal Affairs. Okay? At kapag yung petition is granted, of course, there will be hearing, right? And after the hearing, the IPO would grant B the compulsory license. So even without the consent of X, mabibigyan ng lisensya si B to exploit commercially the invention. But this is, of course, subject to several conditions. Number 1, before B may be allowed to file this petition, there must be showing first that he or she tried to obtain license voluntarily on a reasonable commercial terms. Okay? Dapat nag-try na muna. However, Section 95.2 says that this particular requirement shall not apply when the ground is anti-competitive. There is a judicial determination or administrative determination that the process is anti-competitive. Number 2, when the situation is national emergency or extreme urgency, and when the case is public non-commercial use. Okay? So, right? Now, also, there is also payment then. Meron pa rin payment naman ito ng adequate remuneration. In other words, meron naman kahit paano kikitain si A dito for adequate remuneration. Okay, so anong nababive nyo? No? I hope nababive nyo na parang ano to? Parang eminent domain. Okay? I would say that in certain instance, it is eminent domain, particularly when there is a requirement to obtain license. But if there is no requirement to obtain license, the power exercised by the state actually is more of police power. So I hope natatandaan natin, right? When is taking eminent domain, when is taking police power. Okay, so that is applicable in this particular case. And finally, under the patent law is assignment and transmission of rights. We said earlier that patent is a property, and as a property, it is capable of being transferred to the heirs or assigned. Okay? Ang pinag-uusapan natin ngayon is assignment interviews. Buhay pa si patent owner. And let's say A is the patent owner and A would want to transfer his patent to B. Paano gagawin? Okay, there is a form of assignment. This assignment must be in writing. Hindi pwedeng oral lang. It will not be valid. And it must be acknowledged before a notary public or other officer authorized to perform notarial acts. Right? And these are the formalities requirement. So anong klaseng kontrata itong deed of assignment? Hindi siya consensual contract, right? It is a formal contract. No, there must be observance of this formality in order for the contract be valid between A and B. What about the requirement of recording? Nire-record ba ito sa Intellectual Property Office? Answer, pwede naman. Right? But, okay, assignment not recorded sa IPO is still a valid assignment as between A and B. However, okay, without the recording of the IPO, recording of the deed of assignment to the IPO, it shall not, it shall be void against any subsequent purchaser or mortgagee for value. Okay? So kung ikaw si B, right, I think it's best that you have the deed assignment recorded in the intellectual property office so that you avoid this situation. All right? So those are the discussion under the law on patent.
Gaya ng fridge, kaya medyo na-business niya, kaya sa kondo, mas online siya dito. Siyempre na ngayon ang nasa lamesa, at dito sa left corner pocket ang sisindan niya. Kailangan mapasok ni Efren ang anong bola sa kanyang pocket upang makapuntos. Kahit anong bola sa lamesa ay pwede except sa white ball. Yun, pasok ang 8. Pangatong bola na niya yun. At yun naman, pang-apat na 30 ball, pinagras pa niya para sa susunod na 2. Ang one pocket na isa sa pinakamahirap na strategy game, kaya kailangan na patalasan ng isip at magaling na execution. Magaling na nakuha ni Efren ang kombinasyon sa 6 ball at naipasok niya ang 4 ball sa pocket ni Alex, which is regalo na niya yun. Kapag si Efren sa lamesa, agad sa unang kita, mukhang wala na siyang susunod na tira para doon sa pocket niya. Isa na lang sana at makukuha na niya ang rock na ito. Tinitingnan natin ang pasabog ng Pinoy Magician. Gaya ng fridge, kaya medyo na